Our next speaker is Douglas NeJaime. Did I get that right? Wonderful. He is the Ann Yurovsky Professor of Law at Yale Law School, where he teaches in the areas of family law, legal ethics, law and sexuality, and constitutional law. He was formerly at UCLA, where he was the faculty leader of the Williams Institute on LGBT law. Yes? And his title is?
Constitution of Parenthood.
The Constitution of Parenthood. Sorry, making you do your own introduction.
Thanks. So thanks to David for inviting me, and thanks to Amy for organizing my participation. So I am a lawyer, not a philosopher, and my work focuses on how law treats those who form parent-child relationships, including in the absence of biological ties, including through donor conception. So I use the term biological as law uses it, which includes genetic and gestational connection. And at times I'm going to pull these two terms apart to say genetic or gestational, but law is often sloppy about this and means biological in ways that are simultaneously capacious, to include both, and narrow, meaning only the connection between parent and child. And I study parental recognition by law, which is called legal parentage, so that's the status of being a parent of a child. And this issue arises primarily as a matter of state family law, so it's a state law question, a family law question, but it can also raise constitutional questions, meaning that states must comply with constitutional requirements as interpreted by either state courts or federal courts, including the US Supreme Court. So I normally speak to audiences that one, think that equality based on sexual orientation and gender is a principle to which law should aspire, and two, understand family formation and recognition as necessary to LGBT equality today. And I also start from the reality in which people are forming families in all sorts of ways, including through donor conception. I also proceed from the premise that parenthood is a category that's constructed, that it changes over time, that changes in social practices and norms, including norms about gender, sexuality, and the family, change over time, that law shapes and is shaped by understandings of parenthood, and that parentage is a legal determination, not merely a reflection of biological facts. That parentage, at least in the US legal system, was never merely a reflection of biological facts, and that a range of relationships wholly apart from donor conception have been treated as parent-child relationships in the absence of biological ties. And that law has increasingly come to treat parenthood, as Aaron suggested yesterday, as a practice. But what I'll focus on is how this approach to parenthood developed in ways that privilege men over women and different sex over same-sex couples. So I started with that just to make clear that I think some of the assumptions I normally proceed from are at issue in the conversations we've been having up to this point. And so I'm happy, while I'm moving from those premises, I actually think it's important, and I'm happy to discuss in the Q&A portion why I proceed from those premises. So those who form families through assisted reproductive technologies, donor insemination, in vitro fertilization, and surrogacy, frequently establish parental relationships in the absence of a gestational or genetic connection to the child. And they ask the law for recognition that turns on factors such as intent, parental conduct, and family formation. Yet law fails to value parenthood's, what I'm calling social dimensions, adequately and consistently. And this failure has significant and often painful consequences in the lives of parents and children. Those who have been parenting their children for many years may find that they are not legal parents of their children. Some become legal parents only by engaging in the time-consuming, costly, and invasive process of adopting their own children, and others for whom adoption is impossible remain legal strangers to their children. Some parents may not realize adoption is necessary until it's too late, perhaps when their relationship to a legally recognized parent dissolves. So consider just a few examples. In Connecticut, a married different-sex couple had a child through surrogacy and raised their child together for 14 years. When they divorced, the state Supreme Court deemed the mother, who had neither a gestational nor genetic connection to the child, a legal stranger to the child. There was no, quote, child of the marriage. In Florida, an unmarried same-sex couple used the same donor sperm to have 4 children, with each woman giving birth to 2 children. They raised the children together for several years until their relationship ended, at which point an appellate court left each woman with parental rights only to her 2 biological children. They were legal strangers to the 2 children to whom they were not genetically connected. In New Jersey, a male same-sex couple used a donor egg to have a child through a gestational surrogate. A court recognized the gestational surrogate and not the biological father's husband, who was the child's primary caretaker, as the child's second parent. These last 2 cases happened within the last 2 years. Today, many courts and legislatures seek to promote gender and sexual orientation equality in the family. Judges and lawmakers have repudiated gender-based distinctions in both spousal and parental recognition. For instance, the best interest of the child standard for custody is meant to be a gender-neutral standard. It gets rid of old standards. First, a standard that men had authority over children. Second, a standard that women got custody of children. More recently, courts and legislatures have acknowledged same-sex couples' interest in family recognition and extending marriage to same-sex couples in Obergefell versus Hodges in 2015. The US Supreme Court explicitly sought to protect not only the romantic bonds, but also the parent-child relationships formed by gays and lesbians. So courts and legislatures claim in principle to have repudiated the privileging of men over women and different sex over same-sex couples in the legal regulation of the family. But in parentage law, this privileging remains. As the examples from Connecticut, Florida, and New Jersey suggest, those who break from traditional norms of gender and sexuality, women who separate motherhood from biological ties, for instance through surrogacy, and women and men who form families with a same-sex partner, often find that their parent-child relationships are discounted. So what would it mean to build a system of parental recognition that fully integrates families headed by same-sex couples? And how are questions of sexual orientation connected to questions of gender, such that the law of parental recognition could allow women in not only same-sex but also different-sex couples to assume non-traditional parental roles? My method here is in significant ways historical, situating the contemporary legal treatment of family formation through donor conception within a longer history of parental recognition. So first I'll begin in the common law, then I'll suggest how constitutional law drove shifts in the regulation of parentage in non-marital families, and with respect to unmarried biological fathers in particular. I think I just did that. And next, I'll move to assisted reproduction, explaining how courts and legislatures have turned to social criteria to determine parentage, even as they've integrated parental ties formed through assisted reproduction into existing frameworks of parental recognition. And this allows us to see important asymmetries and inequalities in modern parentage law. So I'll show that even as courts and legislatures have acted to conform parentage law to more recent egalitarian commitments, they reason about parenthood in ways that carry forward legacies embedded in frameworks of parental recognition that were forged in earlier eras. With biological connection continuing to anchor non-marital parenthood, unmarried gays and lesbians struggle for parental recognition. And with the gender-differentiated heterosexual family continuing to structure marital parenthood, the law assumes the presence of a biological mother in ways that burden non-biological mothers in different sex couples, as well as non-biological fathers in same-sex couples. And so finally, I'll briefly suggest some ways out of this, that is how to reform parentage law to accommodate families of this kind without discrimination based on sexual orientation, gender, or marital status. Okay, so first, biological and social factors have shaped the law of parental recognition. The American legal system descended from the English common law, which understood parentage as a relationship defined through marriage, not biology. Pursuant to the marital presumption, also known as the Presumption of Legitimacy, when a married woman gave birth to a child, the law recognized her husband as the child's father. This presumption certainly channeled intuitions about biological paternity, but it also deliberately concealed deviations from biological facts, allowing men to avoid questions of paternity and, more importantly, ensuring a child's legitimacy. Traditionally, neither the husband nor wife were permitted to testify to the husband's, quote, non-access, meaning that the couple themselves could not penetrate the presumption with inconsistent biological facts. By allowing the marital presumption to hide situations in which the husband was not, in fact, the biological father, the law ensured the child's legitimacy because at common law, a child born outside a marital relationship was deemed the child and heir of no one, what the law called filius nullius. Traditionally, the illegitimate child, as historian Michael Grossberg explains, had no recognized legal relations with his or her parents, particularly not those of inheritance, maintenance, or custody. The common law's organization of parentage through marriage reflected and enforced a gender hierarchical heterosexual order, giving men authority over women and children inside marriage and insulating men's property from claims to inheritance by children outside marriage. Slowly, American law departed from the harshest aspects of the common law regime. Legislatures and courts over the late 19th and early 20th century began to recognize a legal relationship between a mother and her, quote, illegitimate child, granting the mother custody and bestowing on the child rights to support and eventually inheritance. In contrast, though, fathers of illegitimate children had financial obligations imposed on them, less as a consequence of a legal family relationship and more as an effort for the government to privatize family support. Even as American law came to mitigate some of the consequences of illegitimacy, the government continued to place substantial legal impediments on non-marital parents and children well into the 20th century. By the late 1960s and early 1970s, in the wake of increasing efforts to hold unmarried fathers financially accountable and to protect the rights of non-marital children, the US Supreme Court intervened. And it intervened by recognizing non-marital parent-child relationships on constitutional grounds. Biological connection served as an explicit basis for constitutional protection for both mother-child and father-child relationships. So in other words, the view that biological relationship gives rise to the legal parental relationship is a fairly modern creation of US constitutional law. Even as the court renounced illegitimacy and dismantled legally enforced gender hierarchy within marriage, it produced a new form of gender differentiation in parenthood, which it justified by resort to reproductive biology. So at the moment of birth, the non-marital child, unlike the marital child, had one legal parent, the mother. A marital child had two legal parents, the mother and her husband. The court explained that gestation and birth evidenced the biological fact of maternity and furnished a relationship to the child that justified legal recognition. An unmarried man, in contrast, needed to demonstrate a commitment to the parent-child relationship, the social practice of parenting, in addition to his genetic connection. So not all biological unmarried fathers were legal fathers. Some were and some weren't. As the court stated in 1983 in Lair versus Robertson, quote, the mother carries and bears the child, and in this sense, her parental relationship is clear. The validity of the father's parental claims must be gauged by other measures. The logic of reproductive biology authorized more far-reaching social and legal differences between mothers and fathers, situating women, but not men, as naturally responsible for their non-marital children. Women became mothers automatically, and thus had child-rearing responsibilities imposed on them, while men often escaped parental obligations. And for those men who desired parental rights, the court relied on biological differences between men and women in ways that discounted their parental contributions after the child's birth. Karib Kapczynski, a family law scholar, describes this as the court treating women as draftees and men as volunteers. Against this backdrop, courts and legislatures in the late 20th and early 21st centuries began to address parent-child relationships formed through a range of reproductive technologies. And they determined parentage in ways that increasingly turned on social and not simply biological grounds, not only for men, but for women, and not only for different sex, but for same-sex couples. Concepts of what I've termed intentional and functional parenthood gained traction in both judicial and statutory reasoning addressing a range of family configurations. So even as principles of gender and sexual orientation equality have animated shifts in parental recognition, parentage law continues to draw distinctions that carry forward legacies of inequality embedded in those frameworks forged in the earlier eras. So the constitutional framework and the common law framework that it repudiated. To be sure, family law in some states has attempted to adapt to developments in parenthood by broadly facilitating and recognizing families, but the focus here is on a much wider swath of jurisdictions where law has rendered some individuals legal parents and left others legal strangers. So I'll start with donor insemination. We already saw the common law organized parentage around the relationship of marriage. The second half of the 20th century, the court intervenes to protect non-marital relationships on constitutional grounds and makes biological connection necessary for legal relationships of fathers. Operating differently for men and women, the gender differentiated logic of both the common law approach and its constitutional repudiation have structured law's response to donor insemination. So I'll start with marriage. Courts and lawmakers initially responded to donor insemination by condemning donor insemination as a threat to the, quote, natural family, and rejecting application of the marital presumption. As a New York court reasoned in the 1950s, because the woman conceived with semen from another man, she was thought to have committed adultery, a crime, and the resulting child was considered illegitimate, the child of no one. Eventually, though, law accommodated the use of donor insemination by married different-sex couples, expanding marriage's capacity to derive legal fatherhood purely from social arrangements. So courts and legislatures began to treat the man married to the biological mother as the child's father. Many states achieved this result through a statute explicitly regulating donor insemination explicitly for married heterosexual couples. In those states that failed to enact donor insemination statutes, the husband of a woman giving birth to a child conceived with donor sperm is presumed the child's legal father by virtue of the marital presumption, or the presumption of legitimacy. Marriage had always served as an imperfect proxy for biological paternity, but by explicitly accepting donor insemination, law embraced social fatherhood in ways that rendered marriage not a proxy, but a substitute for biological paternity. Same-sex family formation eventually injected contemporary questions of equality into the regulation of donor insemination, as women and same-sex couples sought legal recognition for the non-biological mother. At this time, though, same-sex couples were excluded from marriage and thus had no claim on the marital presumption or on donor insemination statutes that applied the marital presumption to different-sex couples. In those situations, the non-biological mother was routinely treated as a legal stranger to the child. More recently, with the onset of same-sex marriage, parental recognition has emerged from presumptions of parentage applicable only to married couples. So courts and legislatures have adapted donor insemination regulations governing married different-sex couples to married same-sex couples. Provisions recognizing the mother's husband as the legal father can similarly treat the mother's wife as the legal parent. In other words, the non-biological mother in a same-sex couple satisfies a presumption of paternity. She is, as a California court explained, a legal father. Strikingly, specific donor insemination statutes have become in some ways ancillary, as states have simply applied the marital presumption to lesbian couples. If law isn't pretending that the individual presumed to be the parent is the biological parent, it no longer seems necessary that that individual be a man. Now, parenthood for both men and women can derive from marriage to the biological mother. Many of these developments emerged solely as a matter of family law, but constitutional commitments also drove judicial decisions applying the marital presumption to same-sex couples. So after Obergefell, courts in many states have held that donor insemination provisions must allow the biological mother's wife to be treated as the child's legal parent, and several courts have held that equal protection requires that the general marital presumption apply to lesbian couples. But the reach of the marital presumption is far from settled. Indiana and Texas are continuing to litigate this issue. There are state governments that continue to defend parenthood as a biological fact and assert that the marital presumption is simply a proxy for biological paternity and thus shouldn't apply to lesbian couples. Yet these very states have allowed married men in different sex couples to use the presumption to derive legal fatherhood of children conceived through donor insemination. No one asks when it's a heterosexual couple. It only becomes obvious when it's a same-sex couple. Now confronted with same-sex couples who make these deviations from biology obvious, these states have struggled to frame the non-biological application to different sex couples as an exception to be minimized rather than extended to same-sex couples. The situation outside marriage is much different. Same-sex couples continue to struggle for parental recognition. Most states draw marital status distinctions in their treatment of donor insemination. So spouses, not unmarried partners, are recognized as legal parents of children conceived with donor sperm. And under the laws of many states, sperm donors are divested of rights and responsibilities only if they donate sperm for use by a married woman. For those outside marriage, biological connections have continued to structure parental recognition. This is particularly problematic for same-sex couples who are not similarly situated to different sex couples as a matter of biological parenthood. Same-sex couples necessarily include a parent without a gestational or genetic tie to the child, and thus are vulnerable in a parentage regime where recognition would turn on biological connection. Yet courts have generally held that laws meet equality commitments as long as a non-biological lesbian parent in an unmarried same-sex couple is treated the same as a non-biological father in an unmarried different-sex couple. And in many jurisdictions, neither of these individuals ordinarily enjoys parentage without adoption. Consider a recent case from Virginia. In Hawkins versus Greece, an unmarried same-sex couple decided to have a child after they were together for several years. Greece was inseminated with donor sperm that she and Hawkins chose together, and the two women raised the child. When they ended their relationship, the child was 7. They informally shared custody for another 2 years, but eventually relations between them broke down, and Greece, the bio mom, terminated the child's contact with Hawkins, the non-bio mom. Hawkins asserted that the state's failure to treat her as a parent of the child violated her constitutional and statutory rights and the constitutional and statutory rights of the child. But in 2018, the Virginia Court of Appeal rejected this argument, reasoning that Virginia's, quote, definition of parent is not inconsistent with United States Supreme Court jurisprudence regarding the nature of the family and parentage, citing the unmarried father's cases I mentioned. The usual understanding of family, the court said, implies biological relationships, and most decisions treating the relation between parent and child have stressed this element. Of course, most decisions are about unmarried parents because marital parentage was taken for granted. Hawkins raised claims of sexual orientation discrimination as well, but the court concluded that the state's, quote, definition of parentage does not discriminate between same-sex and opposite-sex couples. If the couple is not married, the non-biological partner is not a parent, irrespective of gender or sexual orientation, close quote. Biological connection, on this view, is a natural and benign feature of parental recognition that does not treat same-sex and different-sex couples differently. Most states have grafted the two legal regimes that had formed to regulate parentage, marriage and biology, onto donor insemination and thus sharply differentiate between marital and non-marital families. A man and now a woman can be a legal parent of a child conceived with donor sperm if that man or woman is married to the biological mother. In an effort to protect non-marital child relationships that had been excluded by the common law's marital order, courts and legislatures turned to biological connection as a basis for parental recognition, but tethering parenthood to biological ties perpetuates same-sex couples exclusion, and so unmarried non-bio moms ordinarily find themselves to be legal strangers to their children. Okay, now I'm going to turn to IVF, egg donation, and gestational surrogacy. While donor insemination challenged the relationship between the biological fact of paternity and the social role of fatherhood, IVF challenged the relationship between the biological facts of maternity, gestation, and genetics, and the social role of motherhood. By separating gestation from genetics, IVF made biological connection itself a more complex marker of parenthood. The biological fact of motherhood had always followed seamlessly from birth. At common law, the woman who gave birth was deemed the legal mother. But now a woman could give birth to a child genetically related to another woman. Of course, many women used IVF in ways that allowed them to give birth to their own genetic children, but the technology facilitated new practices like egg and embryo donation, gestational surrogacy, and co-maternity, in which a lesbian couple has one woman be the birth mother and one woman be the genetic mother, that divided biological maternity across two women. Courts and legislatures navigated these new situations in ways animated by commitments to gender and sexual orientation equality. Women, they recognized, could attain legal motherhood based on birth or based on genetics, and correspondingly could separate the physical facts of pregnancy and birth from the social role of motherhood. The legal status of motherhood followed not simply from the biological fact of maternity, but from the social performance of parenthood. Not only could women in different sex couples achieve parental recognition based on birth or genetics, but women in same-sex couples could achieve parental recognition by having one woman be the genetic mother and the other gestational. Nevertheless, even as social markers of parenthood became critical to legal determinations of motherhood, a biological connection, whether gestation or genetics, remained critical to legal motherhood. Law continued to ground maternity, unlike paternity, in a biological tie. So consider the use of donor eggs or embryos. Since the woman giving birth was the intended mother, others would rarely know that she was not genetically related to the child. So disputes really didn't arise. When disputes did arise, it was often in the midst of a breakup of the relationship. When the birth mother's husband or partner, because people behave really horribly in divorce, attempted to use the mother's lack of genetic connection to deny her parental status. And as courts and legislatures approached these conflicts, social factors that had begun to shape legal fatherhood more thoroughly in the regulation of donor insemination provided guidance. So a case from Tennessee illustrates. Cindy and Charles, an unmarried couple in their mid-40s, decided to have children together. Cindy, who already had children, was concerned about the viability of her eggs and thus turned to donor eggs and IVF. After Cindy gave birth, she and Charles raised the children together. When they eventually broke up, Charles attempted to use Cindy's lack of genetic connection to deprive her of parental rights to the children. The Tennessee Supreme Court rejected his argument. In recognizing Cindy as the legal mother, the court focused on the fact that both she and Charles intended that she be the children's legal mother. The court looked to the state's donor insemination statute to support its consideration of intent, explaining how that statute, quote, confers parental status on a husband even though the child conceived in his wife via artificial insemination is not necessarily genetically related to him. So too could Cindy, not genetically related to the children, be their legal mother. Courts in other states have analogized egg and embryo donation to sperm donation, and many states have codified this result. They have statutes that divest egg and embryo donors of parental rights and render the intended birth mother the legal mother. Nonetheless, there was an important difference between Cindy, the woman who gave birth to a child with donor eggs, and a man whose wife conceives with donor sperm. The birth mother who uses donor eggs still claims a biological, even if not a genetic, connection to the child. As the Tennessee court explained, Cindy claimed maternity based on the biological marker relied upon in the common law, giving birth. And that fact was critical to the court's judgment. Parentage laws around the country continue to provide that maternity may be established by giving birth. So unlike men whose wives use donor insemination, women using donor eggs turn to intent as a supplement to, rather than a substitute for, biological markers of parenthood. For these women, gestation and birth constitute biological maternity and thus form the basis of a claim to parentage. Intention, the social criterion, supports parental recognition, but only parental recognition that follows from some biological connection. In contrast to the relatively few disputes regarding donor eggs, the use of IVF in surrogacy has provoked much greater controversy in the courts by disturbing the foundational assumption that the woman giving birth is the child's mother. States began to recognize intended mothers as legal mothers if they were also genetic mothers. So intended parents, husband and wife, husband's sperm, wife's egg, gestational surrogate gives birth. Courts increasingly, almost universally, recognize the genetic intended mother as the legal mother. Consider a case from Massachusetts. Marla Culleton asserted that she was, quote, incapable of bearing and giving birth to a child without unreasonable risk to her health. So she and her husband, Stephen, entered into an arrangement with Melissa, a single woman who agreed to serve as a gestational carrier. The embryos gestated by Melissa were created from Stephen's sperm and Marla's egg, thus allowing the Culletons to have their own genetic children. All three parties sought the same relief in court, asking that Marla and not Melissa be recognized as the legal mother. So they had Massachusetts law that didn't do this. All three of them came in because the surrogate said, I don't want to be the legally responsible party for this child. In an earlier case, the Massachusetts Supreme Judicial Court had required adoption by an intended mother in circumstances involving traditional surrogacy, in which the surrogate is inseminated with the intended father's sperm and gives birth to a child to whom she's also genetically related. Yet with the new scenario presented by the Culletons, the court distinguished that case and ruled that adoption wouldn't be required in circumstances of gestational surrogacy where the intended mother is the genetic mother. Marla would be the legal mother and Melissa, the gestational surrogate, would not. Ordinarily, a child born to an unmarried woman, here Melissa, would not be a child of the marriage. But Marla's genetic connection changed the calculus for the court. While the twins technically were born out of wedlock, the court explained, they were conceived by a married couple. And in these circumstances, the children should be presumed to be the children of marriage. Marla didn't attain parentage by virtue of her marriage to Stephen, the biological father. Rather, Marla's genetic connection allowed her to claim legal motherhood, and thus to claim the children as children of the marriage. With gestational surrogacy, a child could qualify as a child of the marriage based on the mother's genetic connection, even if she didn't give birth to the child. Note that that also means that if Stephen was not the genetic father, he would qualify for legal fatherhood by being married to Marla. Taken together, the emerging regulation of gestational surrogacy and egg donation made motherhood a contested biological, social, and legal status. Either gestation or genetics can be the basis of motherhood, and neither gestation nor genetics is itself necessary to motherhood. A woman can be a legal mother when she gives birth to a child genetically related to another woman, an egg donor, and a woman can be a legal mother when she is genetically related to a child carried by another woman, a gestational surrogate. With the expansion of women's reproductive and parental options, motherhood became contingent on social factors. Faced with two women who could claim a biological tie to the child, one gestational, the other genetic, courts turned to intent to determine which mother was the legal mother. While the role of intent is in some ways mirroring determinations of legal fatherhood in the donor insemination context, the legal mother, again, still enacted parenthood biologically, either as genetic progenitor or through pregnancy and birth. Law could preserve motherhood as a biological status, even as it resorted to social factors to determine its legal status. The social factors supplanted biological ties in the donor insemination context, but they merely supplemented biological ties in the context of IVF and gestational surrogacy. Still, the regulation of parenthood through gestational surrogacy signaled something that the regulation of parenthood through egg donation did not. The recognition of genetic mothers as legal mothers and the corresponding non-recognition of gestational surrogates made reproductive biology less central to parenthood, and thus reduced the salience of a key justification for gender-differentiated parental recognition. Remember, I said when the US Supreme Court repudiated the common law regime of illegitimacy, it placed a premium on biological connection, but it differentiated between mothers and fathers by resort to reproductive biology. A woman was automatically a mother because she gave birth, but a man was not automatically a father based on his genetic connection. He had to do something to engage in the social act of parenting. Now, and for constitutional purposes, this isn't seen to pose an equality problem because one of the ways in which you can justify a distinction in law between men and women is to say that it's justified by inherent or real differences between men and women. And reproductive biology was seen as a real difference. Now, in the age of ART, the premium on biological connection aided the genetic intended mother. So now the court said she was like the unmarried biological father in the 1970s. She has a genetic connection and she's stepping forward to be a parent, so she should be a legal parent. Yet by focusing on the rights of genetic intended mothers, courts cleaved the biological process of reproduction from the legal status of motherhood, thus weakening the justification for differences between motherhood and fatherhood. The genetic intended mother was now like the unmarried genetic father. At the same time, the woman who gave birth, who had always been the legal mother, no longer necessarily attained that status if there was another woman who had a genetic tie. So the law's accommodation of assisted reproduction pulled back on the gender-differentiated understanding of parenthood that the constitutional repudiation of illegitimacy had authorized in the name of reproductive biology. This push away from reproductive biology as a justification for differentiated parental status runs out of steam, though, when we hit gestational surrogacy that also involves egg donation. So that's what I moved to lastly. Intended parents who engage two women, an egg donor and a gestational surrogate, struggled to capitalize on law's acceptance of gestational surrogacy. So while legal fatherhood's non-biological capacity inside marriage expanded, legal motherhood largely remained a biological status, even as assisted reproduction complicated motherhood's basis. A woman who gives birth to a child conceived with a donor egg is a legal parent. The biological fact of gestation and birth, along with her intention to be the child's mother, render her the legal mother. A woman who uses her own egg but engages a gestational surrogate to carry the child is a legal parent. The genetic contribution and her intention to be the child's mother render her the legal mother. Social aspects of parenthood now shape determinations of motherhood, but unlike fatherhood, not in ways that dislodge parental recognition from biological connection. So for a woman who both engages a gestational surrogate and uses a donor egg, the law often fails to treat her as a legal mother. Men without biological ties attain parentage by virtue of marriage to the biological mother. But women without biological ties do not attain parentage by virtue of marriage to the biological father. So compare two decisions from Indiana. In infant R, the court allowed the gestational surrogate to disestablish maternity. That means you ask the state to say, you are not a parent of this child. To disestablish paternity when the intended mother was also the genetic mother. Whereas the trial court had denied the request because, quote, the birth mother is the legal mother, the appellate court reversed in light of the state's, quote, interest in correctly identifying a child's biological mother. So now the biological mother was the genetic mother, not the birth mother. But in a subsequent case, infant T, the court refused to disestablish a gestational surrogate's maternity when the biological father's wife, the intended mother, was not genetically related to the child and had used an egg donor. The court concluded, quote, it would not be in the best interest of the child and would be contrary to public policy to allow the birth mother to have the child declared a child without a mother, close quote. Of course, there was a mother to raise the child, but one without a gestational or genetic connection to the child. So while reproductive biology no longer justified gender-differentiated parentage when courts and legislatures confronted intended genetic mothers who had engaged gestational surrogates, it reemerged as a basis on which to reject the sex equality claims of non-biological intended mothers denied parental recognition. So intended mothers who relied on both an egg donor and a gestational surrogate compared themselves to married men who were married to women who conceived with donor sperm. These men can attain parentage without a biological tie to the child. They attain parentage by virtue of their marriage to the biological mother. And remember the Massachusetts case, by virtue of the genetic or gestational mother. And so women who had no genetic or gestational tie to the child said, it is an equal protection problem. You are discriminating against me based on sex, that you allow men married to biological mothers to be parents without biological status, but you don't allow women married to biological fathers to attain that status. Courts have uniformly rejected these claims. As the New Jersey appellate court reasoned, quote, the complained of disparate treatment is not grounded in gendered constructions of parenthood, but in actual reproductive and biological differences. This is the real differences justification for sex discrimination. Such differences are often deemed sufficient to insulate gender-based regulations by collapsing the biological aspects of reproduction with the social aspects of parenthood. The New Jersey court situated the state's regulation of parenthood as an innocuous and natural response to the biological processes of reproduction, one that didn't pose questions of gender inequality. Note that the status of not only the intended mother, but also the gestational surrogate is affected by the fact of donor conception. So the gestational surrogate is not a legal mother when the intended mother is the genetic mother. Remember the infant R case in Indiana. Gestational surrogate says, I do not want to be a legal parent of this child. There's a woman here, she's the genetic mother, she wants to be the legal parent. Court says, yes, gestational surrogate, you are not legal mother of this child. But the gestational surrogate is a legal mother when a donor egg has been used, like an infant T. Her role has not changed. She is doing the same thing. And yet her status as a legal parent is altered based on whether the intended mother contributed to her own genetic material or not. Non-biological fathers in same-sex couples find themselves in a similar position to non-biological mothers in different sex couples. So gay male couples engaging in gestational surrogacy necessarily include a non-biological intended parent. And given that same-sex couples are differently situated from different sex couples with respect to biological parenthood, a non-marital parentage regime we've seen, organized around biological connection, disadvantages same-sex couples relative to different sex couples. But marriage had begun to offer relief to lesbian couples. Given that family-based equality is assumed to grow out of marriage equality, and given judicial statements like one from a New York court saying the child of either partner in a married same-sex couple will be presumed to be the child of both, one might expect that male same-sex couples attain dual parentage by virtue of marriage. Much follows simply from the determination that a child is a, quote, child of a marriage. But parties to the marriage, even if they're not biologically related, have standing to assert parental rights, including rights to custody, but this doesn't reach married same-sex couples who are men. Parentage presumptions applicable to same-sex couples replicate the gender-differentiated rules applicable to different sex couples. So presumptions of parentage for the second parent, even when they apply to both women and men, relate to that person's marriage to the woman giving birth or the biological mother. Accordingly, a woman can derive parentage by virtue of her marriage to the biological mother, as parental regulation in lesbian couples makes clear, but a man can only derive parentage by virtue of marriage to the biological mother, not the biological father. Without biological ties, men in same-sex couples, like women in different sex couples, find themselves in the same position. Neither can establish parentage without adoption. Okay, so observing this feature brings to the surface a key dynamic in modern parentage law. Even in an age of sex and sexual orientation equality, courts and legislatures continue to treat biological mothers as the parents from whom the legal family necessarily springs. This treatment is rooted in the marital presumption and is carried forward by the presumption's adaptation to assisted reproduction. So traditionally, the woman giving birth is the legal mother, and if she's married, her husband is the legal father. Laws adapted this reasoning to different sex and same-sex couples using donor insemination. And it's reached different sex and same-sex couples using donor eggs and embryos when the intended mother is the birth mother. The gendered heterosexual legacy of marital parentage, parentage by virtue of marriage to the woman giving birth, is justified by resort to the gendered heterosexual logic of reproductive biology. But law's accommodation of assisted reproduction reveals the instability of that very logic. Courts are willing to deviate from the gendered logic of reproductive biology to recognize the genetic mother who engages a gestational surrogate to carry her child. Within a regime that prioritizes biological ties, contemporary courts view the genetic mother like the biological father. Courts see clearly that the differential treatment of genetic mothers and genetic fathers poses an equality problem. Yet in considering the claim of a non-biological mother who engages in egg donor gestational surrogacy, reproductive biology persists as a justification to reject her claim to parental recognition. Courts don't see an equality problem when law recognizes a non-biological father as a legal parent but withholds recognition from a non-biological mother. In either of these cases, one could imagine courts invoking reproductive biology to justify the differential treatment of mothers and fathers. In fact, in some of the earliest gestational surrogacy cases, courts rejected the claims of genetic mothers based precisely on grounds of reproductive biology. Motherhood, they reasoned, resulted from the specific act of birth. So a New York court actually early on had said, the birth mother is the legal mother. It doesn't matter if there's another genetic mother because the differences between men and women give birth, men don't. Birth leads to parenthood for women, and it's going to stay that way even if there's someone else with a genetic claim. But today, courts don't do that. Courts disclaim reproductive biology as a basis to withhold recognition from a genetic mother. Indeed, recall that in accepting gestational surrogacy, the Massachusetts court deemed the children of the genetic intended mother children of the marriage. The mother's genetic tie, without any gestational tie, produced marital children. Yet a father's genetic connection doesn't produce marital children, and therefore doesn't offer a route to parentage to a non-bio mom. Reproductive biology continues to justify treating the claims of non-biological mothers differently than the claims of non-biological fathers. Same-sex couples who aren't similarly situated, different-sex couples with respect to biological procreation, remain particularly vulnerable in a non-marital regime organized around biological connection. Marriage furnishes space for the legal recognition of non-biological parents, but with its gender-differentiated legacy, offers relief to only some same-sex parents. Non-biological parents in female same-sex couples attain parentage by virtue of marriage, but that's not true for male same-sex couples. So for a man or a woman married to a biological mother, biological connection is not necessary for legal parenthood. That man or woman is deemed a legal parent by virtue of marriage. But for a woman or man married to a biological father, the lack of a biological connection excludes that individual from legal parenthood. So from this perspective, it becomes clear that the shift toward non-biological parenthood has occurred along only one axis. Fatherhood can capture non-biological parenthood, but legal motherhood cannot. And the collapse of gendered parental statuses has occurred in only one direction. Women can be legal fathers, but men cannot be legal mothers. So on this view, biological mothers are indispensable, essential to the legal family. In contrast, biological fathers are replaceable by men or women who have no biological connection to the child. So the law has traveled a great distance from the common law regime that defined parentage through the gender hierarchical and heterosexual institution of marriage. Yet even with wide-scale waves of liberalization, troubling asymmetries persist. The law continues to anchor parental recognition in biological connection and to organize the legal family around a biological mother. And this leads courts and legislatures to treat men's and women's claims to parental recognition differently and to privilege different sex over same-sex couples. And this treatment has real consequences in the lives of parents and children. Within the contemporary parentage regime, those who believe they are parents on social grounds, including those who have been parenting their children for many years, may be denied parental status by law. Of course, it's difficult to imagine a system that satisfies all those who make claims to parental recognition, right? So you might say, well, courts and legislatures are just muddling through in a world in which reproduction and parenting have become more complicated. But it's especially troubling that the law rejects claims in ways that preserve long-standing forms of inequality. So it's actually not haphazard. This has a logic to it. The burdens of the parentage regime's treatment of social parental bonds aren't distributed evenly. Those who break from traditional norms governing gender, sexuality, and the family by not marrying, by separating motherhood from biological ties, or by forming a family with a same-sex partner are channeled into adoption or denied parental status altogether in ways that others are not. Same-sex family formation ordinarily features non-bio parent-child relationships, and so a parentage regime that anchors itself in biological connection doesn't ensure equality for same-sex couples' families, even if it withholds legal recognition from non-biological parents in both different sex and same-sex couples. Instead, A parentage regime that treats lesbian and gay parents as full participants opens social paths to recognition to both women and men in both different sex and same-sex couples inside and outside marriage. A parentage regime rooted in the gender-differentiated frameworks of marriage and biology also makes outsiders of women who parent children to whom they aren't biologically connected. Courts and legislatures we've seen invoke reproductive biology, but this approach reflects and reiterates traditional understandings of motherhood as women's natural destiny. And it excludes women who break from conventional roles by separating the biological aspects of reproduction from the social aspects of parenting. An approach to parentage driven by gender equality acknowledges that women and men are not similarly situated with respect to reproductive biology, yet recognizes both women and men who parent children to whom they are not biologically connected. So how might law better realize egalitarian commitments in parentage, not only with respect to families formed through donor conception, but across the wider swath of families in contemporary society? So in practical terms, I argue that equality requires law to value social as well as biological contributions in recognizing parents. We can reorient family law in ways that protect the parent-child relationships of women and same-sex couples by grounding recognition more fully and even-handedly in social criteria. These reform efforts occur primarily at the state level. State legislatures can and are restructuring parentage law in ways that credit parenthood's social dimensions. And state courts can apply parentage principles to recognize those who have committed to the work of parenting as legal parents. In my written work, I address multiple ways that family law can protect non-biological bonds of women and same-sex couples. But here I'll just suggest a few important features illustrated by the recently promulgated Uniform Parentage Act of 2017, on which I worked. The 2017 UPA offers state lawmakers a model of reform, and states have begun to enact it. So it's now law in Washington State, California, Maine, and Vermont. First, parentage law can be made gender neutral. Statutory parentage regimes in practically all states remain rooted to varying degrees in distinct approaches to maternity and paternity. While law has increasingly allowed both women and men with and without biological connections to satisfy presumptions of paternity, maternity remains limited to women with biological connection to the child. Accordingly, law facilitates families without biological fathers, but restricts families without biological mothers. Parentage law could move away from separate regulations of maternity and paternity and instead work toward general regulation of parentage. The 2017 UPA is gender neutral and collapses maternity and paternity into parentage. Giving birth is just one of several ways to establish parentage. Second, parentage law should continue to rely on biological connections, birth and genetics, but should also rely on social criteria. The UPA opens paths to non-adoptive parentage based on social and not simply biological grounds. This includes intended parents and de facto parents, ones who are forming a parent-child bond. And it offers mechanisms to establish parentage for these folks. For example, an intended parent can sign what's called a voluntary acknowledgement of parentage along with the other parent, and this form has the force of an adjudication of parentage if it's not rescinded within 60 days. Other states are required by federal law to recognize acknowledgements of this kind. Third, specifically with respect to assisted reproduction, parentage should turn on intent and not on gender, sexual orientation, marital status, or biological connection. The UPA employs a comprehensive and even-handed use of intent, providing that an individual who consents to assisted reproduction by a woman with the intent to be a parent of the resulting child is, as a matter of law, a parent of the resulting child. Even as states open various forms of assisted reproduction on equal terms, they might still devise specific regulations for particular practices. Surrogacy raises concerns with exploitation and the commodification of women's reproductive labor. Lawmakers should and may continue to treat surrogacy with special caution. The 2017 UPA authorizes surrogacy through a specific regulatory framework that seeks to protect intended parents as well as persons serving as surrogates. Regulating in ways that attend to the interests of individuals serving as surrogates does not mean that those individuals are parents of the child. Instead, the intended parents are the child's parents by operation of law, regardless of whether the child at the end of the process is the child they thought they were having or wanted. But the persons serving as surrogates have procedural rights at the outset, including required independent legal representation, and they maintain bodily autonomy rights during the course of the pregnancy, including the decision whether or not to terminate. Even though I focused on state legislative solutions here, reform will likely require constitutional oversight. In fact, the UPA explains to state lawmakers that their existing laws may be, and in my view are, unconstitutional in light of the requirement to treat same-sex couples' families equally. Given the current Supreme Court that we have and dominant frameworks of equal protection and due process, judges are unlikely to appreciate, at least the judges on our Supreme Court are unlikely to appreciate constitutional problems that a biological and gender-differentiated framework of parentage presents. These questions merit close scrutiny. In other work, I argue that properly construed, the Constitution protects non-biological parents who have established parent-child bonds worthy of respect and recognition, but I won't make that argument here. I just want to close with an observation. As I mentioned yesterday, the 2017 UPA also includes provisions that seek to incentivize non-anonymous gamete provision and that require medical information of gamete providers to be collected and available to parents and children. The UPA has been designed by and is being pushed by those of us who advocate for LGBT families. Other alternative family arrangements are also important to the folks who are working on the UPA. Folks in this room, I think, will have to think about the alliances that you want to make and the consequences of some of the arguments that are being made. So will LGBT groups and those of us working on LGBT parenthood be working in coalition with you, or will we be working in opposition? Will reproductive rights groups be working in coalition with you or in opposition? And I think the UPA is an example of coalitional work, but I just heard a lot in this room that move in different directions, and I just thought it'd be productive to have some conversation about that as well. So I'll stop there.
Thank you. Thank you for your talk. Even though it looks like it's moving in the direction of progress, the parentage laws still seem to really be incredibly grounded in gender. How do you foresee the courts to view transgender parents as they relate to their non-genetic offspring, or people that don't identify with gender, they, them?
Yep.
And then to continue speculation, what about relationships that observe more than two people, as with polyamorous individuals? And I'm not quite sure what the laws are as far as recognizing that kind of marriage, or
Yeah.
I'll stop talking.
No, so those are two fabulous questions that are actually very much on the radar of what we're doing. So one virtue of moving parentage law towards gender neutrality is addressing the needs of trans parents. So there's a very troubling case from Maryland in which a trans person who is not genetically related to the child says, I'm the parent of this child and I've been parenting this child. And this person was sex assigned at birth female, but identifies as male, and said, I satisfy a presumption of paternity because I've held the child out as my child. And the lower court had said, no, you're not a father. You would have to be a mother, and you're not a mother. And the Maryland High Court fortunately reversed that decision and adopted a view that one can become a parent if one has established a parent-child relationship that the other parent consented to, and that the child now understands that person as their parent. So we got a good result. But the gender neutrality move would get away from this, which is to say there's multiple ways to establish parentage, and regardless of gender, people can establish parentage in that way. And so the Uniform Parentage Act, when you do a uniform act, this is through the Uniform Law Commission, you're trying to do something that legislators will adopt. And you're thinking of legislators not only in Connecticut and Massachusetts, but also in Arkansas and Louisiana. And so you want to be careful about how you do it. So it's still, one section of the UPA uses the term person giving birth. but other sections use woman giving birth and use woman and man. As we've rolled it out in different states, so I'm working on the bill in Connecticut right now, and we've gone entirely gender neutral, and the Vermont bill that now is law in Vermont has gone entirely gender neutral. So it doesn't use the terms man and woman, it uses terms person or individual. So it's always person giving birth, which means it can include a trans or non-binary person, and all other categories are about person. It still does have a marital presumption that comes from the person giving birth. So in that way, it still is gender, but it's trying to be as inclusive as we could imagine at this point. The other thing that that you raise is a really important issue: multiple parental recognition. And so we have so the Uniform Parentage Act includes a provision for multiple parent recognition. So again, this is always a careful dance as you're trying to get state legislators who generally aren't thinking about the things we're thinking about and don't want to move too quickly to do things. And so when you do a uniform act, you can nudge them in ways. And so one way we nudge them is we have all these ways you can establish parentage. And then there's a provision on, well, what happens if you have more than two people competing for a claim to parentage? And traditionally courts that's come up a lot. You have a husband who's not the biological father and then the biological father, and they compete, and courts have decided. And we're saying, here's how you go about doing that, but we give two alternatives. One alternative is a child can only have two parents, and the other alternative is a court can recognize that a child has more than two parents if not doing so would be detrimental to the child. You bracket those, this is technical, but if you just give it to them and you make one the default option, states are just going to go with the default option. But if you make them have to choose, then they have to have a conversation about it. And so we made them have to choose. And so far, every state that has adopted it has chosen the multiple parent recognition. And California was the first state to do this, so it's modeled on California's act. And it came out of a dispute involving a married same-sex couple and a biological father, in which there were 3 claims to parentage, and the court wanted to recognize 3 parents but couldn't. And so now states are starting to do this, and they have these laws. And recently, there's a decision from a California court in which a woman is married to a man, has a child with through an extramarital relationship with a coworker of hers, but stays married to the man. The husband knows that he's not the biological father. They raise the child together, but the other man also has a relationship to the child. The child's autistic, and they're all participating in developing the care plans for the child and supporting the child. And the California court said this child is fortunate enough to have 2 caring fathers and has 3 legal parents and recognize all parents. And we've separated that from the question of relationship recognition, which is more controversial for people. So people can get behind the idea that it supports children's welfare to recognize their parents as legal parents. And you can do that without saying that if 3 people are in a polyamorous relationship, that they have to have legal recognition as a 3-party relationship, let's say. And very recently, a court in Newfoundland in Canada has had a polyamorous family come before them, not asking for legal recognition as a throuple, but asking for legal recognition of the parent-child relationships, and the court granted that. Yeah.
Hi, so can you talk a little bit about reconciling legal recognition for non-biological parents with accurate record keeping, specifically as it pertains to like birth certificates?
Yeah, actually, I think someone else in the room can talk more, because we were talking about this before. So I think there has to be a lot of work done on educating people about what birth certificates do and should do. There is a impression that people have that birth certificates establish parentage, but they don't. They're just evidence of parentage. So if you look back at early lesbian couple parenting cases, in almost all of those cases, both women were on the birth certificate. It didn't matter to the court. You could put whatever you want on the birth certificate. It's not establishing parentage, but people think it does establish parentage. So I think one thing is educating people so that they see the birth certificate as something other than establishing legal parentage, and then having a conversation about what information would be helpful on a birth certificate. And right now, it's not the case that the birth certificate records biological paternity, at least, and maybe biological maternity in some circumstances, especially because some states have laws that require that when a married woman gives birth, her husband be listed on the birth certificate, even if they're both saying he's not the biological father. And so it also is going to require law reform efforts. Now, I think one way to do this is that what I'm proposing is parentage reform, which happens in the parentage code in family law. And birth certificates are regulated as a matter of vital records or vital statistics. So in Connecticut, for instance, we have separate regulations on birth certificates, and you can keep those regulations and say, let's say that there's a replacement birth certificate if the child's born through a gestational surrogate, but separately have regulation of parentage. But in many states, unfortunately, because there's not a lot of parentage regulation, the courts have looked to the birth certificates regulation as relevant to interpreting parentage law. So I actually am not super hopeful, because I think it's a long-term strategy of educating people about what the purpose of birth certificates are and what they should be in a world in which we're evolving.
Thank you. So I think one problem that arises a potential problem that arises when you increase the possible grounds for parenthood is you increase the possible grounds for conflict. And so I'm curious, what would happen in a case where you had a traditional surrogate who then changed her mind, right? So you might think that this person has a genetic connection, has formed some kind of relationship through the gestational process, but wasn't, at least initially, an intentional parent. And how that might differ from a case when you have just a genetic surrogate, right? And how you might disentangle those kinds of cases. Because it seems like biological factors might become relevant again, and differentiating between gestation and genetic connection and things like that.
Yeah, so let me terminology. So so in parentage law, genetic surrogate and traditional surrogate mean the same thing, which is the surrogate is genetically related to the child. In gestational surrogate tends to be used to mean the surrogate is not related to the child. The child is genetically related to either an egg donor or the intended mother or intended parent. As a matter of parentage law, what's happened over time is that we've tended to treat a gestational surrogacy as something that we allow and regulate, and genetic surrogacy or traditional surrogacy as something that we don't regulate. And so traditional surrogacy has been channeled through the adoption process, meaning that the surrogate would be the legal mother at the moment of birth, and she would have to engage in the relinquishment process and allow and the other woman, the intended mother, would have to adopt the child. That would normally be a step-parent adoption because her husband would be the biological father. I actually think that there's not principled grounds to distinguish between genetic and gestational surrogacy for purposes of parentage. The gestational surrogate, as an empirical matter, we see that people who serve as gestational surrogates also serve as genetic surrogates and don't report differences in their experience, but there's very little work being done on this. From a legal perspective, what's mattering in this? If intent is what's mattering in the gestational context, I haven't been persuaded that the pairing of gestation and genetics somehow makes it something we should treat differently, and I worry that actually treating it differently only reiterates the problem I see, which is saying that women are inevitably, naturally driven to care for the biological child. And if you look at a lot of the anti-surrogacy work, Harold Cassidy, for instance, is the leading anti-surrogacy advocate. He also is one of the leading anti-abortion advocates. He did the South Dakota abortion law, and he litigates the surrogacy challenges in New Jersey and California. And these arguments about regret and the natural bonds between mothers and children, I think reiterate stereotypical arguments that disadvantage women relative to men and maintain distinctions between men's roles and women's roles in the family and the workplace. And so I think actually on principled grounds, in both cases of gestational and genetic surrogates, the intended parents should be the legal parents, and the surrogate's rights should be protected, but that right does not include a parental claim. And I think if you had more certainty around it, you actually wouldn't have you wouldn't have the same sorts of conflict. That being said, the amount of cases that actually result in conflict are like this, and where real conflicts are when parties break up and then they fight over their kids.
Okay, thank you.
Hi, I just wanted to ask a question. I was actually born in Connecticut, conceived in Connecticut, so my question pertains to birth certificates. So I know you're talking a lot about same-sex relationships. My parents were hetero. My legal father my parents divorced when I was a baby. My mother remarried when I was 2. My stepfather is the one who raised me. My legal father had actually tried to do the opposite and threaten he was going to tell everyone that we were donor conceived so he didn't have to support us. So in my case, I would rather my stepfather be the parent on my birth certificate.
Yeah.
What are your thoughts on that?
Yeah. So your father, your legal father under Connecticut. Right. Okay. So your legal father under Connecticut law, the fact of donor conception would not have given him a basis on which to deny legal responsibility under Connecticut law that would have existed at the time. Yes, that was true. And unfortunately, Connecticut law is the same and still says husband and wife, and that's all it's about. But yes, that's what it would have done. Step parents are not legal parents and can adopt the child only if the non-custodial parent, which would be your legal father, consents and relinquishes his parental rights aside from the ability for you to inherit from him. And if he doesn't do that, then the step-parent has no basis on which to form a legal parent-child relationship. Yeah. Yeah.
Just to follow up, I learned 2 years ago I'm donor conceived. So this
Okay.
is like newfound information. So
Okay.
as an adult, can my stepfather adopt me?
Yes, so as an adult, you can consent to being adopted by your stepfather. There are actually a lot of cases involving, not a lot, there are cases involving assisted reproduction in which the intended parent and the person who actually has raised the child does not have a legal relationship to the child. Baby M, the first big surrogacy case, is an example of this, and Melissa, Baby M, when she turned 18, had her mother adopt her. When you're an adult, you can decide someone can adopt you, you are eligible for adoption, and he can adopt you, and you can form that legal parent-child relationship. And there's actually good reasons to do it. Yeah.
Just a quick question. Isn't there a way to do this before the baby is born, like a prenuptial? Is there something, a pre-birth, so they could decide if they break up who takes who? Can you do something in advance?
So you're saying before they actually use any genetic material, or?
Before they have the baby.
Well, what are they deciding?
Before the marriage. Who's going to take what if they break up, or they share, or they share something?
But who's going to
Is
take
there a way to
the
do it?
child or genetic material?
Well, I'm just saying in advance. Can you do it in advance to take care of something legally?
So prenuptial agreements that include care for children are void as against public policy because we actually, so you can agree to lots of things in your prenuptial agreement, but you can't agree to decisions about child support or child custody because the state has an overriding interest in the welfare of the child, and so those are not enforceable. It's also true that if you get divorced and you enter a separation agreement, you can agree to everything on your own, like in a private agreement that's a contract about how you divide assets and what spousal support is. But anything you agree with respect to children has to be approved by the court and entered as part of a decree so that the court has continuing jurisdiction because the state has this overriding interest in the welfare of the child.
Is it mostly maybe it's financial that they want these things done?
Well, I mean, why the courts want to do?
They have these arguments. Is it mainly financial reasons that the one wants it or one doesn't want it?
Oh,
Well, couldn't you cover that already in advance, and that probably takes care of most of the problems, I would think.
yeah, I mean, people argue about lots of things relating to children when they get divorced or break up. So, and I mean, the other thing to be aware of is that often financial arguments are a way to alter other arrangements. So, so it's sometimes pretextual. There are a lot of disputes now about embryos when people break up, and that's a question that continues to be in dispute, and courts have not figured out how they're dealing with that in a uniform way.
All right, Professor, I'm going to come out of left field here, so just bear with me.
Okay.
I'm donor conceived. I was raised by a single mother of my choice. I don't legally have a father. I've also been in the United States Navy for 10 years. So here's my question. So on my paperwork, my mother is legally my mother, and she's also biologically my mother. If I go down, if I get killed in an accident, I die in a plane crash, the Navy is legally required to send someone to her house in a uniform and tell her that.
Yeah.
It's very unfortunate. They're not required to tell my biological father that. Obviously, he's not legally my father. Now, he is going to be informed because I put him on there. I actually, because I was able to find out who he is, I put him on my paperwork. Now, he's not primary next of kin and he's not a beneficiary, but he is on my paperwork, and I wrote a letter saying that he is, if I go down, I get killed in action, please send a letter from the U.S. government. So I kind of wanted to hear your take on this, not only for that, but also because, I sat down with my legal officer about this, and I ran a scenario by her. In a similar scenario, if you had a man and a woman have a child, a couple years down the road, they divorce, stepfather comes in and legally adopts the child, let's say the biological father relinquishes all custody. If that child ends up joining the military and he gets killed in action, they're not required to tell the biological father that he goes down. They're required to tell the mother and the stepfather because he's a legal father, but not the biological child. So right. I got her perspective, the legal of my ship, but I kind of wanted to hear your perspective on that.
Yeah, so I should say in response to all of these, I'm not giving legal advice. So it is the case that what generally we're trying to do is track legal parent-child relationships, and the assumption is because the person with the legal parental status is the person who's responsible and has supported that individual. And so, for instance, with the stepfather who adopts, he's the person who's taken on responsibility, and so he's the person that's deemed the person who needs to know. And so we, as a general matter, just have it turn on the legal status. And so you can have other people in your life who you think should be notified of particular things or are important people in your life, but they don't take on the status of legal parent. And it sounds like the biological donor is not a legal parental status. The weird thing in our law is that we don't have much of it in between parent and non-parent. And I think we've struggled in this room about terminology and how to think about things. And it would be useful for actually us to develop ways of recognizing certain relationships that are not parental relationships, but also aren't nothing. And so we basically just draw a distinction between parent and legal stranger. And grandparents, we've started to do some visitation stuff that gives them some status. There's some step-parent visitation stuff in some states, like California's step-parent visitation statute. So you could imagine that we eventually come up with some way of talking about that has that person be someone other than just this other person who should be notified. But right now, we don't.
Thank you very much. You've given us a lot of food for thought, and I think we need to be sensitive, of course, as a group, to how we can be received by other fields, by other industries, such as the legal field or even the ethics field. Or how would you like donor-conceived people, since our voice hasn't been heard yet? How do you see that happening in these legal cases that come up? Because we want to be sensitive to all families and all different types of families. And I think we also have different points of view. Like, we're not going to speak with one voice. We're going to have a lot of voices. But when we do represent donor-conceived people, if we had 1,000 donor-conceived people from a Facebook group and we were able to say 600 or 700 of them felt in this bucket and another 200 felt this way, would that be helpful to your field? And the other question I have really is about the numbers of donor offspring siblings. And if you could just speak to the legal ramification, if that's also come up in your thinking. Thank you.
Yeah, so I do some work on law and social movements, but my view is probably more law-centered than some other folks in this room. So I think you should take it with a grain of salt. But if what I would do is actually try and organize in a way that can all social movements have a diversity of views, and part of why a movement becomes successful is because they're able to recognize the diversity of views within their ranks, but also produce agenda that people can get on board with. And I think I would advise being able to articulate some set of reforms that seem like they have the buy-in from people in your group, and also are sensitive to the interests of those that you think you can work in coalition with. And I think, so, I've heard both the ban all donor conception and the kind of reform agenda that Aaron suggested, and one of those is going to land very differently in the world of law and policy. And so thinking about how to articulate that, I think, is really important. On donor siblings, Naomi Kahn, who's at GW, is someone you should probably seek out. She's a family law person and writes about donor siblings. Siblings is not really a status in law. There's also a legal historian, Jill Hasday, who has an article called Siblings in Law, to show that basically we don't really have, you don't have particular legal rights. There's some stuff in foster care and adoption regulations about keeping siblings together, but otherwise there's not a lot of legal status as between siblings. And so that might actually offer you opportunities because it's something that hasn't really been elaborated in other settings.
So, is this on? Yeah. So thanks very much. It was very interesting. And I heard a lot about the history of the law, but I was trying to get a sense of what your view is. And it seemed to me that you were thinking that you were arguing for or believe in an intentional view of parenting. And first of all, is that accurate? And second of all, if that is accurate, what on your view counts as intent?
Yes, so my view is my view is actually more functional than intentional. And when I say functional in the family law world, that means that what we're valuing as a legal matter is established parent-child bonds and is informed by work on child development about, from a child's perspective, who do they understand as their psychological parent. And so partly why I think biological connection should be a basis for parental recognition is because it's a good proxy for functional parenthood. So people's social expectations tend to be that people who have biological children should parent those children. And so that is often the case, that the person who has a biological child ends up functioning as the parent of that child. So I'm okay with biological connection being a basis for parental recognition, not because I think there's an inherent importance over other forms of parental bond. And intent is another way. So de facto parenthood is the legal term used for functional parenthood. And a de facto parent standard would say a person can establish their parental relationship as a legal matter if they show that they formed a relationship with the child that's parental in nature, a bonded and dependent relationship, they engaged in consistent caretaking of the child without expectation of financial compensation, and it's in the best interest of the child to continue that relationship. And intent, for me, offers a way to settle some of that at the outset, because it's good for children to have stability about who is their legal parent and makes decisions over them. And so I don't think that if biological connection is producing parentage at the outset, that there shouldn't be an analog for those who form non-biological parent-child bonds. And so intent is a way to get at that. So it's not, there are scholars who defend an intentional view as the view of parenthood, but mine is using intent as a predictor of functional parenthood in the same way that biology does.
Is there any legal system that actually recognizes the notion of progenitor or procreator that doesn't carry any implication of familial life or relation, but could then go on to develop family laws, how a progenitor can establish the family relations that we have to say are social, which seems like gratuitous. I mean, has that ever been considered?
So not that I know of in contemporary society. I mean, in some ways, the early common law system in which men who had non-marital children were made responsible financially, but without any legal relationship, that was essentially saying, you produced this child and we're gonna hold you responsible for the child rather than have the state be responsible, but you have no legal relationship to the child. I mean, that doesn't seem like a good model, but that's sort of something pulling apart progenitor from parenthood, but not something in contemporary law.
So I don't have as much of a question as a kind of question for the room or a thing to think on. I really liked what you were saying at the end of we strongly need to think about who and where we want to build allies. And I think that is particularly apt considering the reaction of some people early to things that were said earlier today. And thinking about that there are many different voices in this room and we cannot speak as one voice. We need to be mindful of all of the voices and remember that the people that were able to come here today are a very select group who had access and the knowledge that this was happening, right? We're not speaking for all donor-conceived people. And so if you reacted positively to stuff that was said today or negatively to stuff that was said today, like that doesn't, we need to think about where we want to ally. And like, I think if we listen to everybody, there are so many points of connection that we can make between our viewpoints. And if we focus on those, we can push forward. But if we are not listening to each other, we're not going to find those points of connection, and large parts of our community are going to be left behind. Like, I have queer parents, and I deeply did not resonate with the things that were said this morning, and I felt very unheard. So I just, like, there are stark differences between what you were saying about, having polyamorous recognition of families, or not even polyamorous, but just multi-parented, versus concepts talked about earlier of having too few or too many parents, and the idea that, pushing that two-parented ideal, that's not an ideal that I hold. And I don't think it's necessarily something that is a super strong point here for everybody, that we need only two parents. I think we all can agree that we all have multiple people in our life that are important, and like that's not something that needs to divide us, but it will if we don't recognize that it's a dividing point.
I mean, I'll just say on that point, I think that's exactly right. And I actually think that some of the things that are said, people are saying them without understanding what the consequences of them may be. Yeah, and so think very carefully about what the consequences of certain arguments are, so that you see, I actually think, yeah, some of the consequences would be unintended. And so how can you think through that? Yeah.
Hi, so I actually want to respond. I'm so glad. Thank you. I absolutely agree with the notion of breaking down these heteronormative ideals of the two parents. I am fully in support. It's interesting to hear your perspective and your perspective as well, because I am LGBT. I'm raised by a single mom who's LGBT, and I was also additionally raised by two women who are LGBT, who are my godmothers. And I am fully against almost every form of donor conception. And I'm running into similar things where now I feel like I'm being labeled homophobic when my views are already contradictory and confusing enough that being told, like, well, how are you going to work with us? Like, how are you going to work with me? How many people who are queer and donor conceived are being asked their views in the first place, and are they on these panels that you're working with? So I just want to echo, like, I'm sure there's more I can do to be aware, and also, like, it feels hurtful to be told or subtextually told that I'm homophobic, because it's confusing enough. I also am single mom, so I also had a question around that, where is there any chance for the kids to be able to have a voice in what they want to choose? In my case, like, I also did not have a father on my birth certificate, and I was also a survivor of abuse, and at no point did I have the ability to make a choice about what was best for my own health.
I mean, so I'll just say something. Now we're like getting into. So I actually took a lot of what was said as people not saying that someone was being homophobic, as much as saying that there are consequences of arguments that get made that have implications in the lives of people who feel that their equality comes with a certain set of entitlements that they're arguing for. And so I will say that I think it's going to be, to my mind, given the LGBT advocacy world, impossible to take the view that all donor conception should be prohibited and have support from LGBT family-based organizations. And that might just be a fact, but it's worth, I think, talking about what the costs of that are and why one might want to proceed in particular ways. And yeah, I mean, the other thing, I do think it's powerful to frame the case in terms of children's rights or the rights of people who aren't part of the process. I mean, one thing that you see in American law is rights are framed in very adult-centered terms. So I guess the only thing I can say from my perspective is that it's a powerful device to speak to people about your experience, and it resonates with people. It's not a powerful legal tool because our courts have been incredibly hostile to the idea that children have rights that should be enforced. And instead, we have the strong view that parents are trusted to act in the best interests of contemplated and existing children. And so we defer in ways too great to the rights of parents. But that does, and this Supreme Court is not going to change that. But it doesn't change it does not change the power of that as a way to speak to people, because that, I think, is deeply powerful.
Okay, one last question, and then we'll take the coffee break.
I'm totally changing the subject. So in regards to birth certificates just being used as evidence, in Australia, in Victoria, I believe, the birth certificates now indicate if someone is donor conceived, and you have to request that birth certificate when you turn 18. So it's still not a guarantee they'll learn that. But do you see it as a possibility, probably on the state level in the United States, that we could add an indication that does not afford any legal rights to donors, but does allow the children to find out that they have a donor?
Yeah, so I guess I'll just go back to something I was saying yesterday, which is that I think part of it is that the claims sort of land in a world in which these things have meaning. And so like the only Supreme Court case that has been dealing with same-sex couples' families as parents is this case Pavon versus Smith from a couple years ago, in which the U.S. Supreme Court told the state of Arkansas that it has to issue birth certificates to lesbian couples that include both women, because Arkansas law requires that when a married woman gives birth to a child, the husband be included, regardless of whether he's the biological father. And so what that means is birth certificates have become an issue for fights over the status of LGBT people. And the state of Arkansas well understood that one way it could resist Obergefell and block LGBT rights was to use the birth certificate. So long as that's the case, birth certificates have meaning that they otherwise might not have, right? And also, donor conception has meaning that otherwise might not have. And so I think it's important. I think it's entirely possible, but I think it involves less of the sort of legal technical stuff and more about being able to speak about it in a way that maintains respect for people's various forms of family formation and treats them as fully belonging, and also centers the rights of children to information. And I think like the open adoption movement is probably a very good model for looking at how successful something like this can be. Yeah. Yeah.
Starting in the 1990s, a new version of the birth certificate was rolled out that states had the option to adopt that had a checkbox. Whether you used assisted reproduction for this pregnancy, and then if there were donor gametes were used. So depending on where you were born and what year you were born in, that may have been in place, not for most of people who are over, say, age 25. New York City, for example, has its own birth certificates, and they didn't adopt this until the 2000s. So you can check with your state, and it's on some births, and it is a self-reported thing. Is it voluntary? It's voluntary, but they've found that it's pretty valid. People have been pretty, I mean, as far as they're able to validate this, it's been validated pretty highly. The sensitivity is in the 90-something%. So that's a reform that was put into place, and I don't know which states have adopted and which haven't at this point, but I think it's pretty commonplace.
Okay, we will reconvene at 3:30. Thank you very much, Doug.